Judge Hill is out sick today, and so I'll be sitting in as vice chair. Would you call roll?
Hill, Wadsworth,
Here.
England, Bedsole, Brinyark, Chestnut, Faulkner, McClammy, Pettis, Robbins, Robertson, Simpson, Starnes, Stringer, Tillman. We have a quorum.
We've got HB 348, but that bill will be at the public hearing. It'll be at the end of the docket. And SB 118 has been carried over, and also HB 260 has been carried over. The first bill we're going to take up is HB 347, Mr. Representative Harrison. Mr. Harrison, would you explain the bill? I think you've got an amendment too.
Yes, I have an amendment coming. HB 347 deals with something that most people have been aware of here for the last few months, the proliferation of the AI notification programs and its inclusion on platforms. The problem is that under our existing law and the federal law, they say they're Section 230 in the federal code and also in the Alabama law, they say we're exempt. The platforms are exempt from prosecution for distributing or creating a private image when found to have solely provided or developed the technology used by another person in the creation of private image. And what this is they upload a picture, okay, and you go in and it shows you how you can take that and either put it on another body or and tell it to do unspeakable things, obscene things. And so that's what we're trying to address here. That's this loophole that says that, hey, we're immune from prosecution. Okay, so that's what this does. And it's not if you have you just have some audio visual editing software platform. Okay, that doesn't, they're okay. Okay, but when they cross over the line and they go in and actively promote and show them, how to do these things, that they've crossed the line. This bill adds an explicit statutory rule. A developer or provider fitting the carve-out is deemed responsible for the creation or facilitation of the illicit material. This ensures that the liability framework applies when the provider is not merely a passive tool maker. Okay, they're still shielded if they're just a passive tool maker, but a knowing and reckless enabler of illegal outputs.
Okay.
And go ahead. I
was going to say, is there an amendment?
Yes, there is.
Who's carrying that amendment?
I've got an amendment, Chairman.
Go forward and tell your amendment, and we're going to ask questions after.
The amendment is, let me pull it up. On line 124 through 125, it's going to change it to say, provider of technology that unreasonably designs. And 146 through 147, limit liability where a developer or provider profits from production or dissemination of a. And then it goes into a long list of procedures, and if the material was uploaded non-consensually, how that individual would, one, take that material down and the process in which to do that, and it immunizes the internet service provider.
Does anyone have any questions about the amendment?
I do. What prompted the amendment? And I mean, I thought the bill looked like a pretty good bill as it was.
Well, I think what prompted it was twofold. One was the process on how to take an image down. I think it didn't have clear guidelines on how, if my image was on said platform, how do I go about getting it down? And so if you read, basically that's all pages, the end of page 1 all the way through page 3, and it defines how to take it down. And we changed, basically the main point was where it already said, let's see, on line 124.
124?
Yeah, this is 340.
Yeah, because 124 currently says shall not apply to any developer or provider of technology that with knowledge or reckless disregard designs, markets, advertises, promotes.
Right, it changes the word from reckless to unreasonably.
Okay.
And I think that was more of a how do we define or understand reckless behavior as opposed to unreasonably.
Okay.
I thought was a better standard.
So unreasonably is a lower standard than reckless then, right?
I mean, I don't know if I can necessarily answer that. I think that unreasonably, I think reckless, I would say unreasonably is probably a lower standard, but it's an easier to define standard as opposed to reckless, because how would you define reckless behavior?
Okay.
Where you could say that there are reasonable steps that you could have taken as the provider or developer, whereas now you didn't take, you could say, well, you didn't take those steps, where how would you have to prove that you behave recklessly as that developer or provider?
Okay, yeah.
I think it's harder.
So I like that one.
Yep.
What's that last one it was the last edit?
The last few pages, that's all about how to take it down. Because there isn't anything in the bill on if it was a non-consensual post on how to go through the process of taking that down.
Okay.
And so it's about mechanisms to communicate to the developer on taking the image down.
Okay. Okay.
Any other questions or comments about the amendment? All in favor of giving the amendment, is there a second? Second. All in favor of give the amendment a favorable report, say aye.
Aye.
Opposed? Is there any other questions on the bill? All in favor, is there a motion?
I so move.
Is there a second? All in favor of giving the bill with the amendment a favorable report, say aye. Opposed? Bill gets a favorable report.
Thank you, Mr. Chairman.
The next one we're taking up is HB 106. Ms. Gibbons, I think she's got to be in another location.
Thank you, Mr. Chairman, committee. This is becoming one of my favorite committees here. Okay, this bill is already an existing law, and what it does, a person commits the crime of doxing if she or he intentionally, electronically shares personal identifying information of another individual with the intent that others will use that information to harass or harm the other individual, and the other individual is actually harassed or harmed. So what Bill 106 does, changes that last sentence, and it's regardless of whether the individual is actually harmed. So that's your only difference in the existing law and Bill 106.
Okay. Is there any amendments to this bill?
No, sir.
Is there a motion to give, any questions or comments? Is there a motion to give the bill a favorable report? Is there a second? All in favor to give the bill a favorable report, say aye. Aye. Opposed? Bill gets a favorable report.
Thank you.
Senator Bell, I see you're sitting out there, but I saw, I talked with Representative Brenier, and he was saying it was being carried over. Is it being carried over? Okay, it's your bill, so you're.
Yeah, I was going to say.
Okay.
If he wants to carry it,
I was going to say, Chairman and Senator, do you mind waiting just 2 minutes, because we've got the amendment that's going to be added. I think that they're going to be okay with is in terms of ALEA, but
is it the same amendment we did upstairs, or do you know? Because that's
it's different.
Okay. I don't.
So
And if he's,
and I just emailed them and said, can you bring it down? And they said they were going to print it and bring it down. So let's just, if we wait, we can go out of order and come back to it, if he's okay with that.
Okay. If that's all right.
or if you want me to just tell you what it is, and because I think what we found out, it's a lot of pages to say a few simple things, unfortunately, and I had to get my own head wrapped around it a little bit, because I kept thinking of a lot more stuff in there that it wasn't, that's already in law, that we've cleaned up, basically doing some cleanup from where we've passed other bills for the healthcare industry and the education industry, where we require them to do the background checks and require them to do all those and keep up with it, the people they're employing and keep employed. So it's cleaning up a lot of the things that we've passed through the last few years into the system, and then having a way back for them to be able to get that information and save some, I guess, man hours with ALEA. And that's really the bulk of this bill.
Okay. What's your position?
It's similar, but I don't know if you remember, the House bill had to get carried over, and so meeting with ALEA, I made several recommendations to make it more passable, I think, and that's what they're printing and bringing down.
If you'd rather carry it over and then let Representative Brinker do it next week, I'm fine with that.
Yeah, it's up to you.
I'm fine with that.
Whatever you want to do.
I don't have a problem with that.
Okay. Well, do you want to wait until they do that, or would you?
I'll be glad to, let's just carry it over. The man of the hour just showed up, so if he gets the amendment and they want to carry it, I'm happy with whatever. I've got to go present to another committee, so.
Let's carry it over. Let's carry it over into next week then.
I'm fine with that.
Okay, thank
Thank
you.
you.
We'll talk about it.
Okay. HB 54, Ms. Hollis. She's indisposed right now. SB 167. If you'll explain the bill.
This is a bill for Senator Orr. They've already passed it upstairs. This bill has to do with amending the Alabama Administrative Procedures Act to revise the standards for judicial review of agency rulings. A person must exhaust all administrative remedies before seeking judicial review. Judicial review is available for final decisions in contested cases. Preliminary agency actions shall be or can be reviewed if final decisions do not provide adequate remedies. Appeals must be filed within 30 days of receiving the agency's final decision. The agency must transmit the record to the reviewing court within 30 days of the notice of appeal. All right, so under the current law, if somebody wants to sue an agency for a procedure, policy, or a ruling against them, the court is limited in how they can interpret agency findings or agency interpretations. Currently, they would have to defer to the agency's own interpretation of their rule. This gives the ability of the court to interpret the rule as they ordinarily would. They can consider the definition or how the agency defined or ruled on it, but they aren't bound to that. They can use their own normal interpretation of the law. So this is advancing the rights of Alabama citizens against governmental agencies that possibly are strong-arming them. So with that, I'd take questions.
Any questions, Representative?
Representative Bringard, we had a version of this bill last session, didn't we? And I think there was amendment or something that was worked out on it last year or the year before. I'm not sure, but because at some point I do believe that there was some hesitancy by some government agencies about the presumption. And I think there was, if I'm not mistaken, there may have been some language that was added, but I don't remember. I was hoping that you could help me out there.
Well, I wasn't involved in it in any prior year if it was offered, but this bill is carefully crafted to only address that when interpreting any statute or rule, the court may consider, but shall not defer to, an agency's interpretation and shall instead interpret its meaning and effect without any presumption as to the agency's correctness. So it's just it's given judicial deference.
Because I think what was added, the court, I think it was before it was shall consider, and that was it. And I think that was added was the may consider, but shall not defer to. Okay. Because I think there was some language added that clarified that it wasn't just, the presumption wasn't against the agency itself. It was, I guess, more along the lines of, like a de novo review, sort of.
Correct.
So, okay. All right.
And this, I don't think there's ever been any deference against the agency, but under existing law, they had to defer to the agency's interpretation. So it allowed agencies to change its rules, and they say, oh, well, we've changed it, and this is how we interpret it now, and the courts had to go with that.
Okay.
So.
All right. Thank you.
Thank you.
Any other questions or comments? Is there a motion to give the bill a favorable report? Is there a second? Second. All in favor, give the bill a favorable report, say aye. Opposed? Bill gets a favorable report.
Thank you, members.
We're going to take Faulkner's bill, HB 328.
Members, this is really not a long bill, as you see, but the amendment that I have here is really just changing the way it's organized and the numbering. It didn't change the substance, but it's kind of difficult, I'm not going to lie, to read it with the amendment. So I think it'll be fine once we get on the floor. But bottom line, what this is doing is we have the crime of arson in the first degree now. And what we're doing here is we're adding it, that requires a person be present in the building, or that you have a reasonable belief that a person is there. But what we're doing is we're adding this to be arson in the first degree if a fire or explosion is set in conjunction with or to effectuate a theft, and the fire or explosion or accompanying theft results in damages of $25,000 or more. So that's what this does. It simply adds to the existing arson law that additional option. And with that, Mr. Chairman, we need to adopt the amendment.
Are you carrying the amendment?
Yes, sir.
Okay.
I move to adopt it.
Will you explain the amendment?
Well, like I said, it just redoes the numbering substantively. It doesn't make any change to what the bill is doing. It's just the way we had it worded. This is a better way to do it. You just include the person being present in the building up there at the beginning, and then you have the two different ways that you can have arson in the first degree.
Is there any other questions or comments concerning the amendment? Is there a motion to give the amendment a favorable report? Stringer?
Yes, I made it.
Is there a second? Stringer? All in favor of giving the amendment a favorable report, say aye.
Aye.
Opposed? The amendment gets a favorable report. Is there any other questions concerning the bill? Is there a motion to give the bill a favorable report with the amendment?
Motion to favorable report as amended, please, sir.
Second.
All in favor say aye.
Aye.
Opposed? The bill gets a favorable report with the amendment.
Thank you, Mr. Chairman. Thank you, members.
Mr. Smithman, I see you, Senator Smithman, I see you out there, so please join us.
Thank you, Mr. Chairman, committee. The bill that I'm here on is SB 195, and it's the Senate companion to Judge Hill's bill as it relates to the concurrent jurisdiction of the probate court and the circuit court. And what it's basically is, much as I'm sure to explain it to y'all, y'all probably could tell me even better that I'm trying to tell you. But what it does is that if no equity has been assigned down in the probate court, then you can still remove it. That was one of those provisions that you had to deal with which the equity part in itself being established.
Is it the same bill as Judge Hill's bill?
Identical.
Okay. Is there any questions concerning the bill?
I'd move to give the bill a favorable report for my fellow colleague from Jefferson County.
Second.
Thank you.
All in favor of giving the bill a favorable report, say aye.
Aye.
The bill gets a favorable report. Thank you, Senator Smithman.
Thank you, members, very much. Thank y'all.
Now, Ms. Hollis, Representative Hollis, are you in? Yeah.
Thank you, Mr. Chair, and to the members, I first want to apologize for carrying the bill over so many times, but myself and Restore Her and Pardons and Paroles had to have a meeting of the minds. So we're there. So I like to say that we have a substitute. So do I need to tell the original and the substitute, or? Just
tell the substitute.
Okay. Okay. Okay, on the substitute, what it does is it applies to pregnant women and postpartum women, defines postpartum as up to 12 months after childbirth. Is newly admitted women that are it covers women that are newly admitted to jail, awaiting sentence to incarceration. It requires intake screening and voluntary testing, such as at the job intake, women must be asked if they are pregnant, suspect pregnancy, postpartum. Pregnancy testing must be offered within 3 days, voluntarily, and conducted privately. They have authorized supervised release. If a woman is confirmed pregnant or postpartum, the court may release her on her own, recognizing that she is not a threat to herself or to the community. Release include non-monetary conditions and supervision. Release may be denied only if the court finds a documented immediate risk, as I stated, to the public. It allows pre-incarceration probation, which means that the court may order pre-incarceration or pretrial probation. Probation may last through pregnancy and up to 12 months after childbirth. Time served on probation is credited toward the sentence. No fines, fees, restitution, or probation costs may be charged during this period. She does have established supervision and services. Supervision determined by the Board of Pardons and Parole may include electronic monitoring and patient reentry programming, requires participation in available parental health care, treatment and assessment, education, and resource programs. They also have created a care coordinator. The Board of Pardons and Paroles must designate a care coordinator responsible include coordinating supervision with the courts and jails, assisting with relief planning, connecting women to health, housing, behavioral health, and parenting resources. It also addresses the pregnancy loss. Pregnancy loss must be reported within 72 hours. Loss is treated as a medical and mental health event. Courts have discretion over which surrender must occur following the loss. Requires self-surrender after postpartum period. Women must self-surrender 12 months after childbirth. Failure to surrender is a Class D felony. And as we know, shackling is prohibited. That's already in fact. So the bottom line is that HB 54 creates a comprehensive statewide framework to delay incarceration for pregnant and postpartum women while maintaining supervision and public safety.
Okay, I believe Representative Bedsoul, I think you have some questions about the sub.
Yes, sir. Thank you. Representative, I just want to first start off, thank you and the organization working with you for the continual dialogue and addressing some of my concerns. And so I just want to mention a few of those and I'm not here to hold your bill up. I'm going to offer my support to this bill today here in committee. Just a couple quick things I hope we can continue. So first I'll say this, fundamentally as someone who used to run a facility, a jail facility, you and I have talked about this. I believe in many instances, many of our really well-run county jails across our state and municipal jails that we can offer good prenatal care to women that are in the facility who are pregnant. And I've seen it in my own facility in which once they come in the door, so I totally agree with the parts of your bill where we talk about doing testing right away. We identify if they're pregnant. And then our medical groups, whether they're contracted or they're our employees, we go to work then to begin to identify a provider in our community in which we can offer them regular visits. We transport the inmates to a facility to get those regular checks. And most importantly, I think one of the safeguards is being inside of a jail is hopefully we keep that individual from going out, and if drugs were a part of their background, if they're on the street, there may be this tendency and lure to go back to an old habit. And when they're inside the facility, hopefully we can keep them clean, which we know if we do that the pregnancy and the unborn child is going to be in better health. So I do believe that the jail facilities across our state can do a really good job. But I like the provisions of your bill. I like some of the work you've done with pardons and parole. What I hope we can clean up a little bit, and you and I have discussed this, is, for example, in Shelby County, our jail doesn't have any interaction with the county health department. We're self-sustained in that we're able to provide the medications that we need to through a system that we have, vaccines and everything. We have nonprofits that we work with. So the provision in your bill that requires if a woman tests pregnant that we have to notify the county health department, my fear is there's going to be confusion because I think our health department, they're not in tune with what we're doing. So I think that will be something that if we could work on, and some facilities obviously they do work with their health department, but the ones who don't, maybe there's a way to say if there is not any dependency with the county health department for medical services, then maybe they don't have to do that provision. Does that make sense to you? What I'm trying? It does. Okay. All right. But otherwise, thank you for all the dialogue and the work that you've done on this particular bill. Thank you.
Thank you.
Representative Pettis.
Yeah, the original bill had 12 weeks, and I say we're going to 12 months.
Pardons and paroles wanted 12 months.
Our state employees, our teachers, When they have a baby, they get to 12 weeks, not 12 months.
Well, the difference is when you're incarcerated, you have to find out who's going to take care of your baby. You have to get everything in order. Whereas a school teacher or someone like your wife got support at home, so you already done laid the foundation for everything.
I just think 12 weeks, and then they're getting credit for this while they're sitting at home. I have a problem with it. Thank you.
Any other questions, Ms. Representative Buchanan?
For clarification purposes, can you tell us why it went to 12 months again?
Well, they just want to make sure that she's getting that, after we have babies, we go through postpartum, we have to get that 6-week, other week checkup, make sure our baby's in good health, and just making sure that that baby's placed with someone they trust so they can be ready to go back and serve their time.
And you said this was recommendation bipartisan parole?
Yes, it was.
Okay, thank you.
Any other questions? Do we have a motion to adopt the sub?
Second.
Second. All in favor of adopting the sub, say aye. Aye. Opposed? No. The substitute is approved. Now we've got the motion. We're going to need a motion, and I'm asking for a roll call on this. Is there any questions on the bill? Need a roll call on the. Okay.
Second.
Second. Okay.
There was no motion for a roll call.
Yeah,
There was no motion. Yeah.
I did.
Okay, please.
Okay. Yeah. Roll call.
Wadsworth.
No.
Ingle.
Yes.
Bedsole.
Yes.
Brignyard.
Yes.
Chestnut.
Yes.
McClamey. Pettis.
No.
Robbins.
Yes.
Robertson. Simpson. Starnes. Stringer.
Yes.
Tillman. Oh, you have a.
Okay. The bill gets a favorable report. Thank you.
Thank you so much, Chair, and to the members.
Thank you. I think we have SB 167. Yeah.
Mr. Chairman, before we move to the next bill, do you think we could contact building maintenance and have the heater turned on? Looks like everybody's a little cool in here.
It is. Yeah. 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 Is someone carrying the bill for Senator Orr? Oh, did we? Okay. HB 263.
It's being carried over.
Carried over. Okay. I think we're down to the public. Yeah, we're down. HB 2.
Robbins is carrying his over?
Yeah. Okay. I think we're to the public hearing now. We've got HB 348, Robertson.
Can I present it here?
Yeah, be fine.
Yes. HB 348, this bill would require an illegal alien who is charged with a violent offense to be detained pending on a pretrial hearing. This bill would authorize a court at the pretrial detention hearing to deny the defendant bail if the court finds that no amount of bail would reasonably assure the defendant's appearance in court. This bill would also establish a presumption that based on the defendant's status as an illegal alien, the defendant is inherent flight risk.
Is there an amendment on it?
There is an amendment, but I didn't know the procedures with the public hearing.
If you could go ahead and explain that.
Okay. I wanted to originally include drug trafficking in with this, but the 12, line 33, violent offense, the term is defined in section 122532, Code of Alabama 1975, would change to if a defendant is a legal alien and charged with an offense enumerated under section 1513.3, Code of Alabama 1975, the defendant shall be detained and is. And under that subsection, the crimes are constitutionally allowed.
Okay. And we're not going to be, Judge Hill's position is we don't vote at the same time with public hearing, so we're not going to vote on it. So the public hearing, we've got 2 proponents and 1 opponent. And the first is Ross, I believe, McLaughlin. You have 3 minutes. Go forward.
Yes, sir.
Thank you.
Thank you, Chair. Thank you, committee. I want to start off by apologizing for my raspy voice. I know I don't sound fine, but I assure you that I am. But I do appreciate the opportunity to address you today. My name is Ross McGlon, and I'm the Chief of Police at Heflin Police Department. I've got over 20 years of law enforcement experience with 3 different agencies, and I've been Chief of Police at Heflin since 2020. The city of Heflin is the county seat of Cleveland County, and we sit right on I-20 in between Birmingham and Atlanta. While Heflin only has roughly 3,500 residents, a Google search says that we get between 120 and 150 additional visitors a day through the I-20 corridor. I-20 also has, or Heflin also has the distinction as having been on the receiving end of violence through an illegal alien. In 2012, a city of Heflin police officer was shot and almost killed. He did live, but it was a career-ending injury. 3 other Cleveland County residents died that day at the hands of an illegal alien. So HB 348 would give the court the ability to deny bail to an illegal alien that has committed a crime of violence through a pretrial hearing, to be able to detain those people without giving them bail, essentially. I think this gives law enforcement another tool in their toolbox to be able to put violent criminals behind bars and keep them there longer. Thank you.
Thank you. We have an opponent, Jerome Dees. Mr. Dees, if you'll explain. Go ahead, go forward.
Will do, just a second. Good afternoon, committee members. Understand that there may be a substitute or amendment coming, so that may slightly change my perspective, but we all understand that while bail is not guaranteed in every substance, in every instance, it is still a constitutionally protected right under federal and state law, with exceptions. In the past, we have seen the state attempt to try and legislate around that, and that has been repealed. We look at the Beeson-Hammond Act of 2011, HB 66, colloquially known as. HB 348, at least as originally filed, attempts or appears to attempt to do the same by restricting access to bail through the legislative process, and significantly expands the types of offenses that are covered beyond those what were previously covered under Anaya's law passed a couple of years ago. That particular process creates 2 significant constitutional problems at the federal and at the state level. First off, because of the way that this bill is written, it presents an equal protection problem because we are looking at a particular suspect class on the basis of the nationality of the individual who has been charged. When we're dealing with suspect classes, we're looking at or equal protection violations in looking at suspect classes. We've got to look at whether that statute has a sufficient governmental interest, if it's sufficiently narrowly tailored, and who that class is. Obviously, public safety is something that is a sufficient governmental interest, but the question is whether the way the law is written is sufficiently tailored, and I think that that is likely to be a problem. Secondly, at the state level, understand that we are expanding the number of potentially charged offenses beyond what is covered in Anaya's law. And because that is a constitutional protection, that requires a constitutional amendment process and not just the legislative act. So I don't want to go too much longer, but I just wanted to flag a couple of things that are problematic just from a legal perspective before the committee. Thank you again for the opportunity to speak.
Thank you, Mr. Dees. Do we have Wanda Miller as a proponent?
Thank you, members of the committee. I appreciate the opportunity to speak to you today. My name is Wanda Miller. I'm the Executive Director of VOCAL, Victims of Crime and Leniency, and we work with crime victims across the state every day. From a crime victim's perspective, the time of arrest is a milestone, as you can imagine. It's a pivotal point. It begins the path to answers and possibly some form of justice. After an arrest, the first questions that we hear from victims is, when is this person going to get out of jail? How much is the bond going to be? Is he going to walk out quicker than he walked in? Why is he allowed to go free? And all of that stuff we can explain because people have rights. And we're not about taking people's rights away from them. But what we are about is when you factor in, as this bill does, a defendant's status. Any defendant that's charged with a very violent crime that might be a heightened flight risk is a fearful thing to consider, not only for the crime victim that's been the victim of a violent crime that this person perpetuated against them possibly. They're not convicted yet, but they've been charged with it. But the public safety part of it, of letting somebody go free or have the possibility to go free, and the possibility that they'll never return to the courtroom again. Where do they go? That's a big question for the victim. And that's something that we considered when looking at this bill. That person may never be held accountable for their actions that harmed a citizen in this violent offense. And the bill is much like a NISE law, a law that we needed, a law that addresses the most violent of offenses. We're not talking about shoplifting. We're talking about when a citizen of Alabama is violently harmed by another person. I think it's something that all of us should care about, and all of us should want to make sure that at least that person is brought back into court for all of us to get answers, most importantly, the victim. The bill gives the court at a pretrial hearing, the opportunity, based on factors included in the bill, to determine whether bail is appropriate. That's fair. That is fair. Judges determine most everything about a case. Allowing them the opportunity to determine whether this person, who's an illegal alien under the laws of Alabama, is appropriate.
Yeah, 15 seconds left.
Okay. I'll go on and say that it is a safety issue. It is a huge issue with a victim, but this bill will allow another step just to assess that defendant's status before allowing his release. And I thank you for your time.
Thank you. Time's up. Does any of the members have any questions to any of the proponents or opponents? Representative England.
Mr. Dees, got a couple of questions for you. Just real quick, you mentioned in your presentation that there would be crimes included under this bill that aren't included in a NISE law. Could you give us an example of what those could be?
I don't have the full list, but I did a quick side-by-side, and I believe there are about 36 new offenses that are covered, because when the legislature was going through the process of a NISE law, I believe they initially started off using just the definition in the code of violent offense. Over time, through the legislative process, that was ultimately narrowed down. I believe last year, actually, there were a few things that were added, like discharging a firearm into occupied dwelling vehicle, what have you, and then some of the inchoate offenses. So that got significantly narrowed down and then was passed through the constitutional amendment process. I believe this starts off back where a NISE law initially was, with just the definition of what is a violent offense, which is about 52 some odd different offenses. And so we've got a gap of about 30 some odd that would, under Alabama Constitution require a constitutional amendment for each offense to become law.
All right, and to follow up, constitutionally, those who are here undocumented, while they don't enjoy the entire gambit of constitutional protections, they do enjoy the constitutional protection of due process.
That's correct.
So that due process comes from, several constitutional amendments, but it's not citizenship specific.
Now, Fourth Amendment, Eighth Amendment, and the 14th Amendment, which then applies that to the state, does not say those rights apply to U.S. citizens, doesn't say that it applies to LPRs or green card holders. It says to any persons. And so that means any person, regardless of their status, gets the benefit of that Eighth Amendment protection, which includes the right to non-excessive bail.
And non-excessive bail is, in fact, a constitutional
at the federal and state level. Alabama is one of the states that has that enshrined in the Constitution. Not all states have it, but that is one right that we have kind of gone above and beyond on, actually.
And so essentially what we would be doing is asking the court to create a suspect classification based upon denying a protected right based on something that the government is not supposed to consider when determining whether or not somebody gets bail.
Precisely. If this bill were to pass and if it were to be challenged, it would be subject to strict scrutiny application on all of the criteria that you've just laid out.
Because at its core, and we're not just assessing the merits of whether or not to do this, but we're talking about when you're in court and we're trying to authorize or tell the judge through a statute that you are to consider something that we have been very clear about: race, nationality, origin, alienage. There are things that you cannot consider when determining if somebody has access to or as protected constitutional right.
That is correct.
Okay, and then and theoretically, how would you envision? 'Cause I know you've done this in the past. So how would you envision this happening in a courtroom? Because I know that being here undocumented in Alabama is not an Alabama offense. It's not a quote unquote crime here. It's a federal offense. So I'm interested to know, and maybe we can flesh this out when we talk about it next week, but what sort of evidence would Alabama have available to it to substantiate whether or not someone is here as a documented citizen or not, that is admissible in court for any purpose without a federal agent being here to do that? So how would we envision that working in court?
You're saying beyond dealing with the appealing or whatever, but in the...
Just like in the nuts and bolts of it.
Jefferson County Circuit Court or District Court, likely, how that would play out?
Yeah.
So if we are at the...
It
would likely... it couldn't take place really within that 72-hour detention hearing. It would likely have to be at the pretrial detention hearing, which would be days down the road.
Right.
So you would likely need to bring in a federal...
Because we don't have those records. We're not a custodian of those sorts of records.
Yeah, so you would have to have somebody that can verify those records, that is in the position to authenticate all of those records. And so for every single individual that was being held under that particular provision, you would have to have somebody to authenticate those records.
We're not a custodian of those records.
Correct.
And this is the last thing, because this is a twofold test in terms of someone being charged with a violent offense is one part of it, but the second part of it which would expand it into those additional offenses. So those additional offenses, with that person coming up before the court, you would consider this expanded list of offenses, but you'd also, at that point, in order to be able to detain them, you'd also have to determine their citizenship status. So there are certain charges that we say you have a right to bail for, right? But there are also certain charges that we say for the average Alabama citizen, if you're charged with them, you do not, or there's a hearing where we could deny that right. But for this subset, the suspect classification, there's an additional number of offenses that are also part of this analysis. And part of that analysis also, for those additional charges, we will be required to consider your race, origin, alienage, or nationality, which for years has been unconstitutional. Suspect classifications, especially for something that's considered a core Bill of Rights, fundamental right, it's very hard for me to remember a time when the Supreme Court said that that was okay in that context, when you're talking about due process especially. So, we could probably flesh this out as the bill moves a little bit, but I think practically it has some significant barriers in order to actually to be functional in a courtroom in any state, in any judicial circuit in Alabama.
I would think that's likely. To be fair, I'd really only looked at it from the academic side of things, because that's generally all I'm going to talk to you all about. But from the practical side of just the jail itself, and again, back when even I was a prosecutor, I didn't handle the processing or anything like that. But I would imagine that creates significant hurdles.
But if I owe you something in 72 hours, a hearing of some sort in 72 hours.
Right.
It'd be very difficult within that 72 hours to produce the records necessary to substantiate your citizenship status in court, even at a lower standard, because of the subject matter you're dealing with.
Yeah. I think when I would handle cases down in Montevallo, back when I was on the private defense side, jurisdictions that don't have the bandwidth and staff to be able to kind of go through all of what would be required within the 72 hours, I imagine just from an administrative and processing standpoint, that would just be a practical challenge as well.
Yeah. And again, it's not something you can just walk into court and say this person is here legally. The standard is if a person is an illegal alien and charged with an offense. So I have to show something beyond just the word of somebody that this person is here legally.
Correct.
Yeah. All right. Thank you.
Representative Chestnut.
Okay. Yes. You are a professor of law, correct?
I am junior. Jerome Senior is the professor.
Okay. And so aren't you familiar with the are you familiar with the case of the city of Hialeah versus the Church of Lakuma Babaluai?
I am not, but I'm sure he is.
That case dealt with targeting of a specific group based on religious identity, right? And so basically it was these folks were cutting off the heads of chickens and using it in a religious ceremony, right? And basically the premise was that if you do something, if you pass an ordinance or a law that targets a specific group, then it is subject to the strictest of scrutiny, right? And instead of it being incidental and an incidental burden upon religious practice versus a targeted focus, specific, specifically making the law just to go after
that gets to
group,
that
right?
Sufficiently narrowly tailored.
That's correct.
Element that I was referring to.
And wouldn't that same legal principle apply in a situation such as this, where you specifically point out and exclude persons who based on their national origin or based on the fact that they were not born here, that they should be denied something that would obviously be available to all others?
I mean, in essence, what the analysis would have to be for the sufficiently narrowly tailored would be that by virtue of the undocumented status and nationality of those individuals, that nationality, alienage, ethnicity is in of itself what creates the sufficient heightened public safety hazard, as opposed to any other nationality.
Exactly, right? And Judge Hugo Black, who's from Alabama, I might add, he was the one that came up with the strict scrutiny standard in Korematsu, correct? And so, with that being said, wouldn't it make more sense to structure this bill to take out that you're doing it because the person is, quote, an illegal alien, and instead say that if a person happens to be an illegal alien, and you can use that as a factor, as a bail factor, to say that this person is likely to be a flight risk based on the fact that he's facing potentially many years.
I mean, to that point, Representative, I'd actually push back a little bit in that judges already kind of have the discretion to determine whether or not somebody, whether they live in Inslee or Pike Road or what have you, is going to be a threat of a flight risk. I mean, every day when I was still a trial attorney, whether I was prosecution or defense, those are the types of criteria and factors that I would either try to present and build up to the judge or try to mitigate and show, like, this person has been working here for X amount of time, that they've got family in the area or what have you. Judges already have the ability to take in all of that information. And so whether you are the prosecutor in that case or the defense attorney, it would be incumbent upon that individual, that attorney, to demonstrate sort of whether or not on the pro or the against side, what that public safety and that flight risk would be.
So would it be a fair statement to say that, as written, this bill mutes and retards judicial discretion?
I mean, it definitely limits what the judicial discretion is. Okay. Just, I mean, in any sort of limiting of discretion on bail, that's kind of in essence what it does.
Okay. All right. That's all. Thanks.
Does anyone else have any questions with Chief McLaughlin or Ms. Miller or Mr. Dees? That concludes the public hearing. We're not going to vote on it this time. It'll be voting on next time. And that concludes the judiciary hearing. Thank you all for coming.